Good morning or afternoon to you all and welcome. Thank you so much for joining Withum today. We have a great presentation in store for you all. And before we begin, I just have a few housekeeping items to cover. You will all be on mute during the presentation. However, at the bottom of the toolbar, you will see a chat box. We encourage you to ask questions during the session, which our guest speaker will answer at the end of their presentation. And this session will also be recorded for future reference, and a link to it will be provided to all attendees. Feel free to share additional thoughts or input after the webinar has wrapped up, as your feedback is greatly appreciated. And with that, I am going to turn it over to today's moderator, Stephen Monticelli, partner and team leader of Withum's Cannabis Sector Services Group.
Alexis, thank you, and welcome everyone. We're really excited to have Richard Rosenberg presenting today. Richard is a partner with Ballard Rosenberg Golper Savitt, located in Los Angeles, and they represent predominantly, there's 25 attorneys that represent business owners in addressing labor matters across the country. And lo and behold, there are many statutory requirements among states that have drafted legislation that require a labor peace agreement in some of the state regulations. And Richard is with us today to explain what all of that means to you as the cannabis operator. And Richard, thank you very much. We will take questions at the end. You can use the chat box, and then I'll come back on and we'll have a Q&A session with Richard at the end of the presentation. Thank you very much, and Richard, good luck.
Thank you, Stephen, and thank you, Alexis, for putting all this together. It is indeed a pleasure to be joining Withum, which is a fabulous organization, and I feel it's a real privilege to be here with everybody today. As Stephen mentioned, my background is I'm what's called a labor lawyer or an employment lawyer, and I represent exclusively business owners in labor and employment law issues. I first got involved in the cannabis industry when Proposition 64 was passed. That was the law, which it was a voter initiative in California, which created the right of a business to sell cannabis without running afoul of the state law. And within that Proposition 64 was this provision requiring a so-called labor peace agreement, which is a labor law concept, which we're going to explain today for everyone. So we titled the program today, Is There a Union in Your Future? Understanding Cannabis Labor Peace Agreements. I've talked to a lot of cannabis operators over the years and since Proposition 64 passed here in California. And what we've learned from them is that there is a lack of understanding how cannabis labor peace agreements are a direct connection to the business becoming unionized. So the purpose of today's program is to put all that into perspective for you as business leaders involved in the cannabis industry. First of all, in terms of surveying the cannabis landscape, we've put a list here down. There's 19 states currently that have legalized recreational cannabis in one form or another. And as we go through the next couple of slides, and this will be presented to you after the program, so you have a chance to look at this in more depth. But you'll see that different states approach this in a different way. The concept I wanted to talk to you about as we get going, though, is what we call labor's outsized influence in cannabis legislation. Essentially, what's been going on, particularly in states like California, it would have been impossible for the legislature to get anything going on cannabis without the backing of one of the largest contributors to the legislative process, which is organized labor. And what they did for themselves in California and what they're doing across the country is they're using their political influence to get laws passed which authorize the sale and distribution of cannabis products in the state. But the quid pro quo for that is that you have to have a relationship with the union through this thing called a labor peace agreement. So what we're going to do today for the next 40 minutes or so is go over that and have you understand exactly what a labor peace agreement is and how it fits into everything in the larger context for labor. In terms of the union influence in the cannabis industry, the big players from the union side are the United Food and Commercial Workers Union. That's the union that represents retail employees generally, and a lot of supermarkets and such. And the United Food and Commercial Workers Union initiated a campaign way back in 2010 called Cannabis Workers Rising. And since then, they've used their political clout to the benefit of the union nationwide in crafting cannabis legislation, which requires, as I said, a relationship with a union in order to be in business. And so what we found now is nearly half the states with legalized cannabis have some sort of what we call labor peace agreement component. Now, in the following pages, we have a list of some of the states. California requires a labor peace agreement no later than 60 days after you have employed your 20th non-supervisory employee. So as soon as you have at least 20 employees, you are required to have a labor peace agreement. But more importantly, when you're applying for your license in California, you have to enter a statement under penalty of perjury that either says you have one or you intend to enter into one once you get your 20th employee. And then what happens is when you go for license renewal, you have to again submit a copy of your labor peace agreement with your application renewal papers, and they won't approve it if you don't have it. Now, Colorado, which is different, Colorado passed a law giving its agricultural workers the right to join and engage in labor unions if they want to. And the union there is lobbying for legislation requiring labor peace. They don't have it yet. Connecticut takes a different approach. Connecticut requires you to have a labor peace agreement and has as an exclusive remedy for any violation of that there be an arbitration between you and the union. And if the arbitrator finds that the licensee violated the agreement, then the regulatory agency is obligated to suspend the license immediately. So that is another approach, a very crafty or clever approach that the union in Connecticut decided to take on this. When we look at Delaware, Delaware passed an ordinance earlier last year, mid-May of 2022. This one is medical only. It would require labor peace. The bills have been introduced in the state legislature, but it hasn't passed yet. So we're waiting on that. Illinois is one of the most aggressive ones requiring labor peace, and it also requires that for employers to get a license, you get extra credit if you have labor peace. So it's like getting a couple of steps up on the ladder. Massachusetts is considering a bill that would require licensees to have labor peace and mandatory arbitration and such. Now, Michigan is an interesting approach because in 2020, their Republican legislature removed the labor peace requirement from the statute in Michigan. And the same thing happened also in Minnesota. Minnesota had a bill which would have required all licensees to have labor peace. It was approved by their House, but the Senate blocked that, and so they don't have a labor peace requirement there. One of the most full-throated provisions anywhere is the state of New Jersey. New Jersey followed New York in terms of time, and then New Jersey looked at what they did in New York, and then they sort of put it on steroids because they not only require labor peace, but they also require that within 100 days, you start collective bargaining and finish that process within 200 days of your opening. And so that puts the business owner under a tremendous amount of pressure to be negotiating a union contract while they're still getting their sea legs up in terms of operating their business. And if you'll note in New Jersey, they give priority to unionized applicants as well. New York also has a labor peace requirement as an ongoing condition of their license. And one of the interesting approaches New York took is they looked at it and said, if you've got 25 or more employees, you're going to get extra credit in your licensing if you used a union construction company to build out your facility, whether it's a retail license or a production license or even cultivation. Rhode Island has a standard one. Everybody's got to have labor peace as an ongoing condition of their license. Virginia has grounds for suspending or revoking your license if you don't remain neutral during any union organizing effort. And so we're going to discuss what that means in a moment, employer neutrality, but essentially it says that if a group of workers want to organize a union in Virginia in cannabis, and the employer exercises rights granted to it under federal law to try to convince employees why it's a bad idea, you can lose your license in Virginia. So effectively, your hands are tied behind you, and you're unable to really aggressively address any effort by your workers to unionize in cannabis. We're not talking about outside of cannabis, only in cannabis. Washington took approach much like California, requiring that you disclose whether you have a labor peace agreement or a union contract before you get going. So you can see that a lot of states are looking at this in different ways, but what we want to understand is how does this fit into the larger realm of the federal law governing union management relations? In this country in 1935, one of the most sweeping civil rights legislations ever to have been passed by the US Congress was the National Labor Relations Act, a federal law which granted to employees for the first time in our country's history the right to form a union or to join a union or to assist a labor organization in its efforts to try to organize a group of workers. Prior to that in the United States, if you tried to organize a union, believe it or not, you could be arrested, particularly in certain states, as engaging in what was called a criminal communistic conspiracy. But with a stroke of a pen, in 1935, the president signed into law the federal labor law, which grants to workers everywhere in the country a right to organize a labor union, and to do so without adverse consequences by the employer. More on that in a moment. Just a little bit of background, cannabis workers, which tend to be younger, most of my clients tell me, are flocking to unions. This federal government agency, which we talked about earlier, this National Labor Relations Board, they've been conducting union elections in the industry, and unions attempting to organize retail industry workplaces, they won more elections in 2021 than they have in almost 20 years. And the Labor Board has put out year-end statistics which show that retail is almost the only industry where unions are organizing workers much more successfully than they did before the pandemic. And the last note I have on there is retail unions prevailed in 60 representation elections overseen by the Labor Board last year, which was up from 37 in 2020 and 34 in 2019. So what's happened is with the pandemic and everything that's gone with it, there's been a lot of big changes in the world, and one of them happens to be showing up here where unions are winning big in cannabis. Now, many of you may read in the newspaper or follow it in whatever news sources you review, the Starbucks, the organizing at other retailers around the country, and you could see that this is a tremendous push for particularly younger workers, but also workers in retail industries. Now, cannabis workers do like unions. In 2021, 26 of the representation elections that were held in cannabis, unions won 18 of them, almost 70%. Now, in that year, most of them were in Illinois, which instituted an incentive program when it legalized recreational cannabis to require that you get extra points in your licensing process if you can demonstrate that you're a labor-friendly organization having entered into a labor peace agreement. And I had put a note here that Cureleaf is one of the companies. They have 3 different dispensaries where the workers have joined the local union there, the United Food Commercial Workers. I might also mention, by the way, before we move on, that the other unions that are very big in this industry, one is the Teamsters. Just as many retailers have opened in cannabis, also there are production facilities, and that fits beautifully into the wheelhouse of the Teamsters Union, which represents companies, as you know, it represents employers, I should say, in companies that are warehouse and distribution operations. And so that's their main impetus, is those organizations, although they work together with the UFCW, you know, in various locations and kind of split up the territory. Out here in California, we have an organization called the United Farm Workers. You may remember them from the 1970s and 80s. Some of us were young enough at the time and we were boycotting grapes and such. And That was the United Farm Workers' efforts to try to get a law passed in California allowing farm workers to organize into a union. And there ultimately was a law in the mid-1970s in California that gave workers in the agricultural industry the right to form and join a union. Now, when we look at labor peace agreements, we need to understand the context in which they exist. Steve and I were talking before the program began, and he asked me a question about, is this federal law, state law, what is it? Well, what it is we have a federal labor law that covers all labor relations throughout the United States, in all 50 United States. And that law is the same everywhere you go. And that law, the National Labor Relations Act, is administered by a government agency called the National Labor Relations Board. And so that government agency administers union representation elections at companies and then deals with the aftermath of that during the collective bargaining process if the union is successful in winning the elections. Now, the states have gotten involved and passed these labor peace requirements. As a labor lawyer, if I can jump off program for just a minute, I would say to you that there is some question about whether these are actually enforceable under federal law, because they are giving states the ability to put their finger on the scale here by favoring labor or not favoring labor, as the case may be, as you saw from the previous slides. And the National Labor Relations Board and the courts have said in years past that labor relations is exclusively the province of the federal law, not the states. But nobody has yet challenged this. And so until somebody does, if you're a cannabis industry business owner and you want to operate, you have to comply with the state law until some court somewhere says you don't. So let's look at how labor peace agreements fit into this larger overall scheme, and then we'll talk exactly about what a labor peace agreement means to your business. So what we're going to talk about today is what is a labor peace agreement, how it fits into the law, and what are your rights and legal obligations under a labor peace agreement. So let's start first with the federal law of union organizing. As I mentioned earlier, the federal law on union organizing is administered through a government agency called the National Labor Relations Board, or the NLRB. Some people call them the Labor Board. I try not to use that name because they also may be referring to many of the other federal and state agencies that deal with labor issues. But the National Labor Relations Board was created by the Congress after the National Labor Relations Act was passed, much like the Internal Revenue Service was created after the Internal Revenue Act was passed. And so the NLRB sits in Washington. It's got field offices around the country. One thing I'd like you to know about this organization, it is one of the most inherently politicized agencies in all of federal government. The president appoints the members. The custom is that there's a 5-member board. 3 are whatever's in the White House. So we have 3 Democrats right now and 2 Republicans. When we've had Republican administrations, that usually switches to 3-2, sometimes 4-1. And the decisions of the National Labor Relations Board reflect the background of those political parties. So right now we have President Biden, as you know. He's a committed labor advocate. He campaigned on labor expansion. He's appointed people to the NLRB from the union side who are making decisions every day as we speak that are some of the most pro-union NLRB decisions we've seen in decades. I've had the privilege of toiling in this vineyard for almost 45 years now, and we are seeing the most aggressive pro-union decisions of any time in my entire practice. And we'll talk about a little about in the next few minutes. So we have the National Labor Relations Act and the NLRB, and they are running labor relations in the United States. Now, first of all, I want you to understand, I get this question, who can organize into a union? And I want you to imagine for a moment that if you were looking at a blank piece of paper and you drew a thick black line, let's say from east to west, and above it you wrote the word supervisors, and below it you wrote the word employees. Anybody who's not a supervisor, anybody who can tell others what to do, when to do it, and how to do it in your company, they can't be part of a union. But anybody who doesn't have that authority, if you haven't deputized them to give them the authority to tell others what to do, when to do it, and how to do it, maybe get them in trouble, for example, if they don't, comply with the requests that you ask of them, those people can be in a union. So one of the things I have up here, this slide, management's special role, because I want you to know that in the eyes of the law, anyone who you've deputized to give them the authority to speak on your behalf when it comes to workers is going to be considered a legal agent or representative of the company, and what they say and do is deemed to be company conduct. And what that means is that if they say or do something without your permission, like they mentioned to one of your employees something like, well, if you, I don't know what the boss would think, but I'm telling you, if you tried to form a union around here, I'd see to it that, and then you fill in the blank. You get fired, you get suspended, you don't get the shift you want, I'll take away your vacation, doesn't matter, whatever it is. If you're doing something to them in retaliation for having tried to organize a union or to dissuade them from organizing a union, because the person who's doing that speaking is an agent of the company is responsible for everything that person does. So first and foremost, we need to figure out who's on our team and who's on their team, and make sure that our team is properly educated in the things that we're going to be discussing for the next few minutes. Because in my experience, occasionally but rarely is it the owner of the company that gets the company in trouble. It's usually the supervisors who are talking with the workers on a day-to-day basis, who, if they don't know where the rules are, what's coloring inside the lines, what's coloring outside the lines, they say and do things which cause the company to have compliance issues with the federal government. So we'll talk about that. So the federal government, the National Labor Relations Act, sets out 3 different ways that a business can go from becoming non-union to union. And I want to talk to you about those briefly. The first way is to have a government supervised secret ballot election. We're in election season now with the fall coming upon us. Before we know it, all we're going to be hearing about is the elections for the next few months. What the NLRB does is when a group of workers or a union presents evidence to the government that at least 30% of the workers in a group that the union wants to organize wish to be represented by a union, they'll come out to your business some 4 or 5 weeks later. They're going to set up a ballot box and allow people to vote whether they want to be in a union or not. And then they'll count the votes, and whichever pile is bigger is the winner. So there'll be one question on the ballot. Do you want to be represented by this union, yes or no? And if a majority of the workers who vote that day say yes, then the business is organized with a whole cavalcade of obligations, which we're going to discuss in a minute, that flow from that. Now I have here the letters ALRB, which stands for the Agricultural Labor Relations Board. I put that up there, particularly for those of you in California. The federal labor law, when it was passed in 1935, excluded 2 groups of workers, 2 big ones, agricultural workers and government workers. The feeling was that this dealt with private industry, but the agricultural lobby just wasn't strong enough at the time. And so as a result, agriculture was excluded from the protections under this law, which is why I mentioned earlier that Colorado passed the law, for example, allowing agricultural employees to organize. Because the NLRA, the National Labor Relations Act, does not cover agricultural employees, whether cultivation workers can unionize is going to be dependent on state law. So again, if you go back to where we were, we said there's 3 ways to become union. The first way is the National Labor Relations Board, or an ALRB supervised secret ballot election. The second way is what's called a voluntary recognition. Now, when the government passed the National Labor Relations Act, one of the things that happened almost immediately is some very clever employers came up with this idea that we're worried about the Teamsters or the commercial workers of this union or that union. So what we'll do instead is we'll form our own union to keep those unions out. But the government says that this really belongs, these decisions, to workers, not to the company. And so they allow workers to organize with a union. And when they reach a magic number of majority, meaning 50% plus 1 of that group, then the employer for the first time is privileged to allow the union to become the exclusive bargaining representative of the workers. Until that happens, it's illegal for the employer to confer recognitional rights on a union that does not represent a majority of the workers. So the majority status can either be determined by a secret ballot election, or the law does allow an employer to voluntarily recognize a union if it wants to, provided that it is presented with evidence that at least the majority of the workers have signaled an interest in joining the union. Typically, by the way, that's done by having some kind of a petition or some kind of a statement that says, we, the undersigned employees, wish to be represented by the union. And again, the employer is privileged, if it wants to recognize the union in that case, if it's signed by 50% plus one of the workers that the union is seeking to organize. Now, what we're going to see in a few moments is that a labor peace agreement is essentially a contract with a union for a voluntary recognition. It has conditions on it, which I'm going to explain to you. But basically, at its core, a labor peace agreement is a contract with a union that says, when we can convince a majority of your workers to be union, that in lieu of going through a secret ballot election sponsored by the government, you will voluntarily recognize us. You will confer on us the right to be the union with all the legal obligations between the company and the union that flow from that decision. So a voluntary recognition is choice number two. The big deal about a voluntary recognition is there's no election. The other big deal about a voluntary recognition is that theoretically it disenfranchises 49% of the workers, because as soon as the union hits 51%, it stops and can go to the company and say, we got you, you're now union, because you signed this agreement for a voluntary recognition. And so again, we'll talk a little bit more about the details of that, but this is number two. The third way that you can become union is that if you color outside the lines that the labor board has set up for how you can address employees who are trying to unionize, and you commit what they call unfair labor practices. Unfair labor practice is a legal jargon. It's in the National Labor Relations Act, which describes a series of behaviors that if employers do those things, they're violating federal labor law and there are consequences for it. The most draconian consequence possible is where the NLRB forces the company to recognize and deal with the union because the employer committed so many unfair labor practices that the federal government believes that employees, if they were to have a secret ballot election, would be afraid to vote as they wished because they'd be too frightened about the consequences given what's happened so far. So once again, we have three ways to do it: a secret ballot election, a voluntary recognition, or if the company commits too many unfair labor practices. And again, when I say company, remember I'm talking about your supervisors, not necessarily just the owner of the company. Then they can force you to become union even after the union lost an election, by the way. That's an extraordinary remedy and it's out there. Now, the federal law gives employees certain rights. They have the right to form and join a union. They have a right to assist a labor organization, and they have the right to engage in something called other concerted action for the purpose of collective bargaining or mutual aid or protection. That's a mouthful. What it really means is that employers have to understand that employees have a right to get together as a group to express concerns about shortcomings in the workplace or things that they want changed. And so to that end, this concerted activity is protected by the law, just as forming a union, joining a union, or assisting a union. So anytime a group of workers get together, now what is a group? A group is more than one. Anytime a group of workers express concerns about the workplace, even if you're a non-union company, you're covered by this law, the National Labor Relations Act. It applies to basically every employer engaged in interstate commerce. So if you have a telephone and you make phone calls out of state, you are covered by this law. If you have goods and services that you sell or distribute or use to build your products or whatever your business is, those activities place you under this law. So employees have the right to form or assist the union or engage in other concerted activity for their mutual aid or protection. Those terms, by the way, have been interpreted since 1935 in thousands of NLRB cases, and we'll discuss a few of what they mean. So employees may join an organizing committee. They're permitted. They can also show their support by wearing union buttons at work. If employees show up at work and they're wearing a union button, something that says UFCW or Cannabis Workers Rising or something like that, you cannot tell them to take it off. If you do, that's committing an unfair labor practice, except in certain technical aspects of the business where you could argue maybe that in the manufacturing process or even in cultivation, in certain very narrow circumstances, that if the button were to fall off, for example, and get mixed into the product, that it would cause some kind of contamination. Employees are also allowed to, at work, solicit or try to sell co-workers on the idea of becoming union. In other words, talking, using their words to talk about union. Solicitation means trying to sell somebody on an idea. Now, you should have a company policy on solicitation. It should be reviewed by your labor counsel who knows something about this area of the law, because many companies write a policy that says, for example, you're not allowed to solicit. Well, that policy is illegal because employees have a federal right to solicit coworkers within certain limits. They are not allowed to do it when they're supposed to be working, but they can do it on their non-working time, like their meal break or their rest breaks, or before work or after work. They can do it in the employee cafeteria or break room, depending on the size of your business. They can do it in the parking lots. They got lots of rights. They also have rights to hand out literature. And again, the government says they have a right to do it at work, so long as they're not doing it when they're otherwise supposed to be working. But I do tell clients all the time, watch out for discrimination. If you have a company policy that doesn't allow for solicitation, and you only use that policy when it has to do with union stuff, you're going to have a lot of explaining to do at the NLRB. So, for example, if you've allowed employees to post a notice that said, so-and-so's leaving the company in a couple of weeks, we're going to have a potluck dinner to celebrate them, who wants to chip in or something? And then somebody else posts a notice that says, there's going to be a union organizing meeting next week at the such and such hotel. Whoever wants to go sign up. And you tell them to take down that notice, but you allow the other notice for the potluck dinner. Well, that's illegal discrimination under the National Labor Relations Act. So you have to be able to know that your management team understands these rules and that they are uniformly applying these rules. Also, employees, and this gets a lot of employers really, if I can use a labor law term for a minute, pissed off. And that is employees have a federal right to criticize management and to do so publicly. Now, it doesn't mean that somebody walks into your retail establishment and somebody says, you shouldn't buy from here because the company's owner is an idiot. Something like that would be illegal, and you could deal with that. But could they stand outside your business, for example, and say, hand out literature to your customers saying that we don't think it's a good idea to patronize this business because they're not paying fair labor wages? I think the answer is yes. They also have the right to withhold their services. Now, the collective withholding of services is called a strike, and strikes are protected activity under the federal labor law. And of course, they have the right to partake in any kind of concerted activity as it relates to wages, hours, and working conditions. So the federal labor law puts a lot of constraints on how an employer can respond to an effort by a group of workers who are trying to organize a union. And Starbucks found out handily right now, Starbucks is in the midst of a federal prosecution by the NLRB seeking a national injunction, a court order against Starbucks and its management team for all the supposed unfair labor practice activities that have occurred in the run-up to the union elections, which have occurred in the Starbucks around the country. Now, the federal labor law grants to workers certain rights. At the same time, ladies and gentlemen, it also grants to workers the right to be free from any adverse consequences from management for having the nerve to engage in these protected activities. Now, the law says management cannot interfere with, restrain, or coerce employees in the exercise of these activities. Well, for heaven's sakes, nobody understands what those words mean, because those are legal terms that are just in the statute. But what we can say is that in 75 years of jurisprudence, the government has come up with a whole lot of ways to describe those terms: interfere, restrain, and coerce. And what they've basically said is that if companies are not allowed to threaten employees that something bad is going to happen to them if they unionize or try to unionize, by the same token, they're not allowed to promise or bribe employees that good things will come to them if they stay away from the union. Like, I'll give you a raise if you don't sign that petition for the union, or I'll give you the vacation you want, or this or that, or I'll promote you or something. You're also not allowed to spy on union activities or survey union activities, as it's referred to in the literature. So if employees are holding a union meeting, for example, and you know where it is, excuse me, you're not allowed to go to the parking lot and write down the license plates of the people who are showing up and take action against them. And finally, you're not allowed to retaliate against workers by taking adverse action against them because of their union activities. So the federal labor law basically says we want to encourage workers to have the freedom to make a decision on their own without influence from management about what is and is not in their best interest when it comes to the union. And management is constrained significantly in how it can respond to those efforts. So if you find out that a group of workers in your company are trying to unionize, you should connect immediately with Labor Counsel who knows this area of law, because there are a lot of things which you can do, plenty of things you can do, but also a lot of things that if you do them, you'll get in trouble for doing it. And you could end up in the worst case analysis with being unionized, even if a majority of your workers never voted for it. Now, understanding this concept, how does labor peace fit into this? Well, first of all, you need to understand that labor peace requirements are inserted into the law to give the union a leg up in organizing your employees. Now, the political intention here, if you think about a labor union for a minute, you know, the labor unions would like to sell you on the idea that they're a service organization, much like the Red Cross, and they're just there, you know, sort of materialized out of nowhere to do good for the world. And I'm not saying that there haven't been labor unions that have improved working conditions for workers, because clearly they have. But the political intention here was that when cannabis got created as an industry, the union wanted a piece of it, because if you think about the business of a union, the union sells memberships. And it's financed through union dues that are paid by unionized workers. Usually the dues are taken out of their paycheck and remitted to the union. And so the union said, we want a piece of this industry. And if we can get tens of thousands of good paying jobs occupied by unionized cannabis workers as opposed to non-union cannabis workers, well, that's a huge, huge payday for the unions. So their view was they're looking at tens of thousands of new union jobs, which are being fulfilled by union members paying them union dues. And the first step in becoming union is the labor peace agreement. So let's talk about what is a labor peace agreement. I'm giving you here the California definition, but the definitions in the other states are pretty similar. So a labor peace agreement is an agreement between a licensee, you know who that is, and a bona fide labor organization. They put that in there so you can't have the Joe's Cannabis Union. You have to have a real union. And what does it do? Well, it protects the state income, you know, that flows from the sale of cannabis by having an agreement that the company won't lock people out and the union won't engage in any kind of picketing or work stoppages or anything else like that. So the company does get labor peace when it signs up for a labor peace agreement. But what it also gets is something else that is very significant, and that is an organizing obligation. The labor peace agreements generally mean that the employer will not say or do anything which is going to disrupt efforts by the union in their goal of communicating with and attempting to organize your employees. So the labor peace agreements typically have a requirement that you have to have access where the union is permitted to come onto your property to talk to your workers during the workday, not to disturb them when they're working, but it's usually during their non-working times, such as before work, after work, or during their lunch or meal breaks. And these meetings are held for the purpose of influencing employees and educating them about their rights under labor laws generally, and this law in particular. Now, the key features of the major union LPAs, the critical one is management neutrality. You know, if you see that statue, a little statue of the three monkeys, see no evil, hear no evil, speak no evil. Well, the same thing. Management neutrality, it muzzles management. Management has to be neutral. An employee says, boss, what do you think about a union? I can't say anything. Talk to the union about it. It's up to them and you. So management neutrality is a key feature which the major labor unions will insist upon if you want labor peace. Suppose you say, well, I don't want to sign that. Well, now you're in a quandary, aren't you? If you need labor peace as a condition of getting your license, and you can't find a union that will give you a labor peace agreement without management neutrality, then you're really in a bad place, aren't you? Which is why so many hundreds and hundreds of companies all over the country have been signing these labor peace agreements. So you need to understand that the labor peace agreement is the first step to becoming union, because first of all, management is giving up its right to talk about why the union may not be in the best interest of the employees. Most labor peace agreements also have a requirement for union access to the facility. Typically, you'll work out where and when this is done, and the union won't be able to disturb employees working, but most labor peace agreements have a provision for access. Many have provisions that the company will actually have a paid meeting without management present to try to talk to the employees about the union. Something else, under the National Labor Relations Act, if a group of workers file for a secret ballot election, about a week later, you have to furnish the government, who in turn furnishes to the union, a list of your employees' names and addresses and cell phone. With labor peace agreements, they want it now to facilitate their ability to bother employees at home and to get access to these employees. They want you to furnish that information to them right away. So if you think about this, you're going to have management neutrality, you're going to have union access, and you're going to give the union information about how to reach your people so that they can have those conversations with them and try to convince them why a union is a good idea. The other main thing that's going to happen is, in lieu of a secret ballot, you're going to have a voluntary recognition. They call it a card check. That's labor law jargon for a legal process which allows workers to make the decision whether to be unionized simply on the basis of a petition or these pledge cards that people sign. It's something of that nature. So the card check in lieu of a secret ballot election, which is what I mentioned to you earlier in the slides as choice number 2. Also a collective bargaining trigger, meaning that you have to commence bargaining with so many days and may even have to finish within a certain amount of time. And if you don't finish, then the whole question about what you're disagreeing over goes to an arbitrator who will then set your wages or your benefits for you. This concept of interest arbitration is really one of the most frightening things in the labor peace area, because what it does is it gives the union an incentive not to agree with you during union organizing, because then they throw it up to an arbitrator who can say, well, you know what, the prevailing wages in the community are 50 cents higher than what the employer is offering, and we're just going to say you have to pay that. And so these are things which are major features in union labor peace agreements. A couple of other key features, we talked about this: no strike protection. Well, that helps the company, which is good. No lockout protection means that if you're in a dispute with the union, you can't shut the place down and lock out their workers. Union cooperation. Union cooperation is a good thing. We have found that typically the major unions, the Teamsters and the United Food and Commercial Workers and a few others, they are willing to use their influence before state and federal agencies and local politicians on matters of mutual concern. So usually a good LPA can have a union cooperation provision. Some are more full-throated than others. And finally, you need to know that the labor peace agreement, if you decide that you like your cannabis business, but not that much, and you decide to get out of it, if you sell the business, whoever buys your business has to comply with the labor peace agreement which you've signed. Those are the kinds of features that the major unions are asking for. Now, once a group of workers becomes union, you inherit a legal duty to bargain. The words duty to bargain are 3 little words, but they mean just a ton of things. The most important thing it means is that from that point forward, once you flip the switch and you've recognized the union to be the representative of your employees, you have a legal duty to meet with the union and discuss and agree upon anything, any change to wages, hours, and working conditions before you implement. Just imagine, this is like hiring somebody to sit on your board who has made no investment in your business whatsoever, but they have veto power over your right to make decisions, critical decisions that touch wages, hours, and working conditions. To give you some crazy examples, the US Supreme Court supporting the National Labor Relations Board years ago that said, if you had a candy machine in your business or a vending machine of any kind and you raise the prices, before you do that, you got to talk to the union and get their agreement. So this duty to bargain means that you've got to negotiate and discuss with the union endlessly until you reach an agreement with the union, or you've bargained to such an extent that you reach this magical state of impasse. Impasse is a legal term for labor law that is much like this phrase in matrimonial law, irreconcilable differences. What does it really mean? Well, for every couple it's different, and in every bargaining session it's different too. But generally what it means is that you've been trying to get the union to agree to something and you're at loggerheads for so long that it's now a waste of time. So that's the first part of the duty to bargain. The second thing is the union gets to ask you for all kinds of information about your business that you've got to give them. Anything that touches wages, hours, working conditions, and a lot of your finances, you're going to have to share with the union in certain contexts. If it touches wages, hours, or working conditions, you have to provide it if the union requests. And then finally, the third part is the duty to bargain means discipline matters. Even before you have a union contract, the NLRB has said that you have to involve the union in any kind of serious discipline that could result in discharge or at least suspension of the employee, or any time that the employer has any kind of discretion in the process of the initiation of the discipline. If you had a rule, though, that said, for example, if you're late 3 times, you get a warning, you don't need to involve the union if they're late 3 times. But if you had a policy that says if you're late too many times, you can get a warning, and it didn't specify a number, then in that circumstance, you would have to involve the union, for example. So you can see that when you sign and enter into a labor peace agreement, you're entering into a process which eventually is designed for you to become union. It's designed for you to become union because the unions know that without their entering into the labor peace agreement, your license is jeopardized. You need them and they need you. And that's the essence of labor peace. I'm now open for questions.
Richard, that was terrific. Very insightful on what to do and what not to do. I think cannabis applicants and license holders and operators, they wrestle with many obstacles in getting these businesses launched. You look at cultivation, you look at manufacturing, you look at retail, many of these vertical businesses, they're businesses in and of themselves. And coming along with the challenge of labor and the labor peace agreements and what this all means, I'd like to just focus on just a couple things as it relates to the economics for the operator.
Sure.
Clearly, I think, what have you seen? And I know it's a variety of states. I'm just curious as to the impact economically of what happens when we have a labor peace agreement in place and it goes union. Now, clearly, New Jersey and New York are very new on the scene, and they're probably not a good representative sample right now to figure out the outcome. But can you speak a little bit about some of the experiences you've seen with cannabis companies throughout the country? And then we'll go back to some of the questions that we've got through the chat.
Sure. Well, first of all, you said it right, and I want to say it one more time a slightly different way so people understand. Labor peace agreement, signing that in itself will not cost you anything. But labor peace is the first step down the road to becoming union. And once you become union and you inherit this legal duty to bargain with the union, now things change, because one of the things you have to do is sit down with the union and negotiate for what's called a union contract, or a collective bargaining agreement is the more technical name of it. And the things that are covered in a collective bargaining agreement are all kinds of things that touch wages, hours, and working conditions. So almost assuredly, you're going to have a raise in the contract. And usually the union contract sets forth a schedule for how raises are determined and how often, and every 6 months or every 12 months. I had the privilege a couple of years ago, when cannabis was really new in California and New York, to represent a large national cannabis organization in negotiating union contracts in California and in New York. And they had retail operation in New York City, and in upstate New York, they had their production facilities. And it was clearly a 15 or 20% cost increase on the employer, because There were wage increases. They had to agree to a certain number of holidays. They negotiated a certain number of paid time off, leaves of absence, certain other benefits. So there are all kinds of things that go into a union contract that have a cost element to it. That's usually where the increased costs are experienced. It's usually not in the signing of the LPA. That in itself doesn't feel like anything happened. But it's once you become union and now you're under the auspices of the National Labor Relations Board to conduct yourself legally and in accordance with the many rules that the government has implemented requiring employers, as I said, to negotiate and bargain with a union. Another thing which is a little bit crazy right now is the NLRB's chief cop in Washington, D.C. is a well-known union side lawyer that has been bending the rules considerably. Imagine this scenario. An employee claims that they were fired in retaliation for their union activities. Normally what would happen is the government would send you paperwork, and some few months later you would have a trial on that issue. You'd put on evidence, and when it was all over, a judge a few months later would render a decision. If it was in your favor, great. If it was against you, well, then you could appeal it. And the employee, meanwhile, is sitting on the sidelines. Under the current administration, the Biden administration's top cop on this for labor, what they're doing is going into court and getting injunctions requiring you to reinstate the employee that you fired before the trial on whether he deserved to be fired or she deserved to be fired. And they're also going after companies that change benefits and having them reinstate the benefits. And also, they've added a new specter to this. Generally speaking, up until this year, if an employer committed an unfair labor practice, for example, by firing an employee illegally, and they had to reinstate the employee, they would give the employee back pay and their job back. Now they're entitled to consequential damages, which include things like if they had medical insurance and because you fired them, they couldn't afford it and they got sick and they ran up a big hospital bill, you're on the hook for that. And so there's tons of things that are going on out there. Emotional distress damages, pain and suffering damages. If they can prove that they lost sleep over losing their job or something, they can sue you just as if it was a personal injury case. This is what the federal government's doing to us in this administration. So there's lots and lots of costs. But what you should assume, Steve, the short answer is it's more expensive. Now,
yeah, no question.
Yeah.
So no question. And I think some of that cost is going to be passed on to the consumer because, you look at California as a rather large state, but some of these states are relatively small with some of the firms in the industry close to the borders. And, you've got consumers who are price sensitive these days, provided it doesn't take more than a gallon of gasoline, which is at a premium. You may have people driving over the border to shop at dispensaries.
And something else we've experienced, the unions are just not interested in hearing you talk about the Internal Revenue Code 280E, which everybody on this call understands is that provision of the tax code, which doesn't allow you to deduct the business expenses that are typically deductible. You can only deduct the cost of the goods sold. And we've had clients here who, working with their financial advisors, jumping through hoops, trying to cover things in different categories that would ordinarily be costs that you could cover. So an employer in California should be able to deduct, for example, the cost of their workers' comp insurance, but you can't under 280E. So that becomes a very difficult discussion because the workers want more, the union wants to get more from them, and yet the non-union shops or the illegal shops that are operating, they have lower costs. They don't have to pay all the taxes. They don't have to worry about 280E and all those things. So those union contract negotiations can get very difficult.
So just a point of clarity, when we're talking about a dispensary only that's not vertical, yeah, they're bound by some inventoriable cost rules that it's basically cost of the product, and you're going to wind up losing, in addition to the additional cost, you're going to lose out on that deductibility. But for the ones who are involved in the manufacturing and cultivation, provided you've got a proper labor allocation to the cost of the product, we can certainly include the cost associated with any labor associated with their efforts. So yes. I think it depends on the firm.
And clearly this is a place where they have to have somebody like you, Steve. I mean, an expert in the accounting and tax laws and cannabis to know how to best position themselves for that. And that's not the province of the labor lawyers. We just get consultation with folks like you and then try to put across the table the best offers we can.
Understood. We've got a comment from someone in the New Jersey market, and there may have been something in the slide earlier relative to the New Jersey market that may be inconsistent with the regulations. So just as a point of clarity, I just pulled up the regulations in New Jersey, and apparently a labor peace agreement with a bona fide labor organization has to be considered when you've got an applicant issued for a conditional license for a cannabis establishment, distributor, or delivery services other than a micro business shall be a requirement for the final approval for an annual license. So the failure to enter or to make a good faith effort to enter into a collective bargaining agreement within 200 days of the opening of a licensed cannabis establishment will result in a suspension or revocation of that establishment's license. So that is just something to watch in New Jersey. There's a 200-day requirement there.
And just to make sure everybody heard that for the New Jersey folks on the call, that's a collective bargaining agreement. So you have to enter into labor peace, then the union has to organize the group, and then you have to negotiate a union contract and get that all done within the first 200 days. And that is that's like warp speed. I will tell you, having negotiated hundreds of union contracts over the years, a first contract can typically take 6 months to negotiate because you're starting from a blank page, and everything that you put in the contract is going to be there forever once you have it. So it's very important, all the words on the page, yet New Jersey wants you to run through this as if none of those words matter.
Richard, you talked about a no interference by management. You know, one of the questions that came in, and it says, you know, what if someone's the labor union visits the premise and they've got these buttons about, you know, unionize or what have you.
Right.
And the question is, what if the buttons go against the dress code? Can you order them not to wear them?
The general answer is no, you can't. The federal government has dealt with this issue of the dress code for decades. We actually won a case about 30 years ago, 25 years ago, during the Bush administration for Starwood hotels, where we convinced them that everything that wasn't black, you know, that was their whole marketing scheme, was the whole look of, you know, the ultra cool, you know, hotel experience thing. But generally speaking, the only way you can stop somebody from wearing a union button is if you can show some sort of special circumstance, and just having a policy that says it's not part of the uniform is not enough. You have to be able to show that it would contaminate the product, or that it would, in some manner, result in a safety concern.
Richard, what do you tell the operator who basically wants to dig their heels? You know, despite the fact that these labor peace agreements and the initiatives are in the regulations contingent on their license. In order to keep their license, they're going to have to comply with the union, basically. And, you know, what happens if someone starts digging their heels and they're basically interfering where technically they're not supposed to interfere? Does it result in a strike? Does it result in some negotiation with the state? I guess it depends on the regulatory body in each particular state as to how they'll look at a license renewal at the end of the year.
In my experience, the licensing authorities don't give a whit about the why. You either have it or you don't.
Yeah.
And then on the why side, if the company wants to dig in its heels, it'll be in a prosecution by the National Labor Relations Board. And that's where things can get very testy. And as I said, with the Biden Labor Board that we have in this administration, the remedies and the actions of the government are much more extreme than anything we've seen in the past. Now, whether that will continue if we have a change in administration again, you know, probably not, but we just don't know. But the Labor Act is, as I said, it's been the bedrock of this since 1935, and little parts of it change here or there, or how aggressively they pursue something or not pursue, but the basic rules haven't changed. So, you know, for this, what I said before is cannabis is one of those, is the only industry I know of in the United States where as a condition of being in business, you have to have a relationship with a union. And that's why I think it's illegal, but somebody's got to challenge it, and nobody's called me up yet and said we're willing to stick our neck out. They're enjoying the business that they're in, and are willing to put up with all this nonsense that comes from having to, and the difficulties that come from having to manage around either labor peace or a collective bargaining relationship.
Richard, I think this was excellent, and I thank you very much for this very insightful program. Certainly, I believe an operator who's in one of these states is clearly going to need a firm such as yours in order to meander through the obstacles and or the twists and turns associated with operating this in a way in which will permit you to continue with licensing as usual. So I think you're offering a valuable service to those states where the requirement is. Your email is in the PowerPoint presentation, and I'm sure Alexis would be happy to email this to anyone who sends her an email. And thank you very much, everyone.
Pleasure to be with you. And you know, this is a very complicated topic, Steve. And in the hour that we had, I tried to give you the big signposts that people need to watch out for. Obviously, every one of these slides has nuances to it which need to be explored as people have very specific questions. But it's my pleasure to be with you. Withum is a fabulous organization, and I feel privileged to be part of your team today. Thank you.
Have a good day, everyone.
Have a good day.